Chapter 10, Maintenance of Public Order and Tranquility. It is divided into four parts. They are A. Unlawful Assemblies, B. Public Nuisances, C. Urgent cases of nuisances or apprehended danger, and the fourth part, D. Disputes as to immovable property. Before we start this chapter, let's make the basic things strong. It is divided into four parts, and I have done the color coding as well. And do not forget that we need to remember the sections. Part A, Unlawful Assemblies. It is given as per the provision of section 129 to section 132. Total 4 sections. Second part is Public Nuisances. It is covered as per the provision of section 133 to 143. It has got 11 sections in total. Part C, Urgent Cases of Nuisances or Apprehended Danger. Only one section, section 144. Fourth part, Disputes as to Immovable Property. It is covered as per the provision of section 145 to 148. It got total 4 sections only. To learn all these sections now, how do we remember these parts in serial orders? Well, take an example of a movie. We go to a movie and it is certified UA. UA is for everyone, but over here we say Unlawful Assemblies. If a movie is UA, then there will be definitely a public. And if there is public nuisances. And if there is a public nuisance, there is a reason for apprehended danger. Because public creates nuisance and there might be some danger, and then there is going to be a dispute to immovable property because property is also at danger. You can also make it as UPUD or any other thing which you want to remember it in serial order, because only then you can remember the sequel of sections distributed to all the 4 parts of this chapter 10. Let's begin with the first part of the chapter, Part A, Unlawful Assemblies, which is as per the provision of section 129 to 132. Do not forget, first part contains 4 sections. The first section of Part A, Unlawful Assembly, is Section 129, Dispersal of Assembly by Use of Civil Force. Let's check Subsection 1 of Section 129. It says any executive magistrate or officer in charge of a police station, or in the absence of such officer in charge, any police officer not below the rank of sub-inspector may command any unlawful assembly or any assembly of 5 or more persons likely to cause a disturbance of the public peace to disperse, and it shall thereupon be duty of the members of such assembly to disperse accordingly. Now, subsection 1 says that If there is an unlawful assembly is of five or more person, how it can be dispersed, how it can be removed. It is the duty of executive magistrate or officer in charge of a police station. And if both are not available, in absence of both, any officer of police station not below the rank of sub inspector, this is to be noted that he should not be below the rank of sub inspector. What are they going to do? Well, they can command the unlawful assembly to disperse, to go away. And what if it is not successful? What if they don't listen? Then subsection 2 of section 129 comes into force. Let's read that. If upon being so commanded, any such assembly does not disperse, or if without being so commanded, it conduct itself in such manner as to show a determination not to disperse, any executive magistrate or police officer referred to in subsection 1 may proceed to disperse such assembly by force and may require the assistance of any male person not being an officer or member of the armed forces and acting as such for the purpose of dispersing such assembly, and if necessary arresting and confining the persons who form part of it in order to disperse such assembly, or that they may be punished according to law. So, subsection 2 of section 129 says, if unlawful assembly does not disperse as per the commands of the executive magistrate or the police officer, then they can use little force. Subsection 2 of section 129 says, little force can be used with help of male persons, but they should not be member of armed forces. They should not be member of armed forces means not military, army or navy personals. It further says it can confine, it can arrest them as well for further legal action. Second point of unlawful assemblies is section 130, use of armed forces to disperse assembly. Now let's check what this it says. Subsection 1 of section 130 says, if any such assembly cannot be otherwise dispersed, and if it is necessary for the public security that it should be dispersed, the executive magistrate of the highest rank who is present may cause it to be dispersed by the armed forces. Now here we can see the difference between the two sections as well. Section 129 says there will be no use of armed forces, whereas section 130 says there will be use of armed forces if the unlawful assembly is not being able to be dispersed, but this will be done by executive magistrate of highest rank. Now let's check subsection 2 of section 130. It says such magistrate may require any officer in command of any group of persons belonging to the armed forces to disperse the assembly with the help of the armed forces under his command, and to arrest and confine such person forming part of it as the magistrate may direct, or as it may be necessary to arrest and confine in order to disperse the assembly or to have them punished according to law. So subsection 2 of section 130 gives power to the executive magistrate to command the armed forces to take action accordingly, whether to arrest them, to confine them, or take any other necessary steps. Let's check the third part. Subsection 3 of section 130 says, every such officer of the armed forces shall obey such a requisition in such manner as he thinks fit, but in so doing he shall use as little force and do as little injury to person and property as may be consistent with dispersing the assembly and arresting and detaining such persons. Now, subsection 3 of section 130 gives power to the executive magistrate to take such action that may cause little injury and it may cause damage to the property as well, to disperse the person or to arrest the person who is causing unlawful assembly. So this is all being done to command to take control of unlawful assemblies. Third part of unlawful assemblies is section 131, power to certain armed force officers. Section 131 says when the public security is manifestly endangered by any such assembly and no executive magistrate can be communicated with, any commissioned or gazetted officer of the armed forces may disperse such assembly with the help of armed forces under his command and may arrest and confine any person forming part of it in order to disperse such assembly, or that they may be punished according to law. But if while he is acting under this section, it becomes practicable for him to communicate with executive magistrate, he shall do so and shall henceforward obey the instructions of the magistrate as to whether he shall or shall not continue such action. Section 131 basically says that when the unlawful assembly is becoming dangerous and there is no executive magistrate to be contacted, then any commissioned officer or officer of armed forces will take command. They will do whatever necessary to disperse the unlawful assemblies, and he can use the force as well. Now, again, we have a difference between section 130 and 131. 130 says executive magistrate will command, but 131 says if no executive magistrate is being able to contact, an officer of armed forces can command to disperse unlawful assemblies. However, when executive magistrate is available to be contacted or when communication is being done with him, then the officer of armed forces will obey the instructions of the magistrate. He will not take action on his own. So it is true to the title of section 131 that it has given some powers of certain armed forces officers to disperse assembly. Condition is executive magistrate was either not available or was not able to contact. Now we come to the fourth and the last point of unlawful assemblies, section 132, protection against prosecution for acts done under preceding sections. Subsection 1 of section 132 says no prosecution against any person for any act purporting to be done under section 129, 130 or 131 shall be instituted in any criminal court except A. with the sanction of the central government where such person is an officer or member of the armed forces, B. with sanction of state government in other cases. Now, officers has taken action to disperse unlawful assemblies. Definitely there will be an injury to persons. Now such person cannot sue these officers, either the executive magistrate or the armed forces, for their action because they were doing their duties. However, they can be sued with permission, with the sanction of the central government if they have to sue the member of the armed forces, or if they have to sue other person, the permission of the state government has to be taken. Now subsection 2 of section 132 says A. no executive magistrate or police officer acting under any of the said section in good faith, no person doing act in good faith in compliance with requisition of section 129, 130. C says no officer of armed forces acting under section 131 in good faith. D part says no member of the armed forces doing any act in obedience to any order which he is bound to obey shall be deemed to have thereby an offense. So definitely they have taken action in good faith. So no action will be taken against these members, whatever they have taken under section 129, 130 or 131. Now subsection 3 of section 132 says, in this section, in the preceding sections of this chapter, clause A of subsection 3 says the expression armed forces means the military, navy or air forces operating as land forces and includes any other armed forces of the Union so operating. Clause B of subsection 3 says officer in relation to the armed forces means a person commissioned, gusted, or in pay as officer of armed forces and includes a junior commissioned officer, a warrant officer, a petty officer, a non commissioned officer, and a non gusted officer. So, officer definitely means anyone who is associated with the armed forces. Clause C of subsection 3 of section 132 says member in relation to the armed forces means a person of armed forces other than officer. So the word member denotes person of armed forces but not an officer. Now we come to the second part of the chapter Maintenance of Public Order and Tranquility, Part B, that is Public Nuisances, as per provision of section 133 to 143. Total 11 sections are given in this part. Part B, Public Nuisances. The first point is Section 133, Unconditional Order for Removal of Nuisances. Subsection 1 of Section 133 says whenever a district magistrate or subdivisional magistrate or any other executive magistrate specially empowered in this behalf by the state government on receiving the report of a police officer or other information on taking such evidence if any as he thinks fit considers. Clause A says that any unlawful obstruction or nuisance should be removed from a public place or from any way, river, or channel which is or may be lawfully used by the public. We have seen that a lot of agitation is done, road blocks are done, roads are blocked, so the government has to take action to be used by public to remove such nuisance. Clause B of Section 133 says that the conduct of any trade or occupation or keeping of any goods or merchandise is injurious to the health or physical comfort of the community, and that in consequences of such trade or occupation should be prohibited or regulated, or such goods or merchandise should be removed, or the keeping thereof regulated. The first thing to learn, the section deals with cases of public nuisances and not private nuisances. The second thing that we learn from this section is a proceeding under section 133 should be taken in case of emergency, where the public shall be put to great inconvenience and shall suffer an irreparable injury if the encroachment or nuisance is not removed at once by adopting the summary procedure contained in this chapter under the topic nuisance. Now let's check further what can be public nuisances. Clause C, it says that the construction of any building or disposal of any substance as is likely to occasion conflagration or explosion should be prevented or stopped. See, this is in relation to immovable property, a building which has to be brought down or has to be built up or amended. So such things is also gonna be a nuisance if it is not done as per the rules and regulations. Clause D says that any building, tent, or structure or any tree is in such condition that it is likely to fall and thereby cause injury to person living or carrying on business in the neighborhood or passing by, and that in consequences the removal, repair, or support of such building, tent, or structure, or the removable or support of such tree is necessary. So this is also a nuisance if we see there is an old building, a tree, which is on the verge of falling. Either we can ask the government through this that it should be supported, it should be repaired, or it should be removed. Next, clause E says that any tank, well, or evacuation adjournment to any such way or public place should be fenced in such manner as to prevent danger arising to the public. Now, this is regarding the public path, which has to be repaired, done properly for the use of the public. Clause F says that any dangerous animal should be destroyed, confined, or otherwise disposed of. Such magistrate may make a conditional order requiring the person causing such obstruction, nuisances, or carrying on such trade or occupation or keeping any such goods or merchandise or owning possession or controlling such building, tent, structure, substance, tank, well, or evacuation, or owing to or possession such animal or tree within a time to be fixed in the order. So we here see that even if we see that there is a dangerous animal in the city, in the village, there is a right to protect themselves, to defend themselves, and to confine such animal or even to tranquilize that animal so that a public cannot be put at danger. Next, further, it says, clause I, to remove such obstruction or nuisances if there is on public. Clause 2 says, to desist from carrying on or to remove or regulate in such manner as may be directed such trade or occupation, or to remove such good merchandise or to regulate the keeping thereof in such a manner as may be directed. So even it has to be regulated, it cannot be done in public areas. Third says to prevent or stop construction of such buildings or to alter the disposal of such substance if it is required. Clause 4 says to remove, repair, or support such building, tent, or structure, or to remove or support such tree if we say that it is dangerous to the public, it is falling, or it may fall. Fifth point comes to fence such tank, well, evacuation. See if it is a well of water or any other thing storing which is chemicals which is can be a dangerous, it has to be under protected walls, fence, so that there is no danger to the public or neighborhood. Sixth point comes to destroy, confine, or dispose of such dangerous animal in the manner provided in the said order, or if he objects to do so, to appear before him or some other executive magistrate subordinate to him at a time and place to be fixed by the order and show cause in manner thereinafter, provided by the order should not be made absolute. Now we know that dangerous animals cannot be taken as pets as well. It is dangerous to the society whenever they are let loose. So, if they refuse to take the precautionary measures, well, they can be given notice to appear before the executive magistrate and they can be made to take such measures so that public is not at danger. Now, subsection 2 of section 133 says, no order duly made by a magistrate under this section shall be called in question in any civil court. Now, obviously, this is a public nuisance, so this is a criminal matter. And if it is a private nuisance, it's gonna be a civil matter. So, any action taken by the magistrate in a criminal case, in a public nuisance case, he will not be challenged in a civil court for the same. This is what subsection 2 is explaining us. Now we have an explanation to section 133 as well. It says a public place includes also property belonging to the state, camping grounds and grounds left unoccupied for sanitation or recreative purposes. So public places just not malls and shopping malls and cinema houses. It can be any place even if it is unoccupied. Second point of nuisances is section 134, service or notification of order. Subsection 1 of Section 134 says, the order shall, if practicable, be served on the person against whom it is made, in the manner herein provided for services of a summons. Subsection 2 of Section 134 says, if such order cannot be served, it shall be notified by proclamation published in such manner as the state government may by rules direct, and a copy thereof shall be struck up at such place or places as may be fittest for conveying the information to such person. Now, the nuisance has been caused, and it has been caused by various persons or one person. We have to summon such person, we have to serve the notice to such person. If it is not practicable, subsection 2 says you can paste it at a conspicuous place so that it can be informed to such person. The summons can be conveyed to such person. Third point of public nuisances. Person to whom orders is addressed to obey or show cause as per the provision of section 135. Section 135 says, the person against whom such order is made shall, clause A says, perform within the time and in the manner specified in the order the act directed thereby, or the clause B says, appear in accordance with such order and show cause against the same. See, under section 133, we covered nuisances to be removed by executive magistrate, how it can be removed with conditional orders. Section 134, we read that notice is to be served. And now we come over here that in the notice, we can give two options to the person. First, he may perform within time specified in manner as given in the orders, that how the nuisance has to be removed. Second option is that he may appear in accordance with such order and show cause against it, that why he is doing so. It's causing public nuisance, man, you have to remove it. Let's take up a case for example. In Nagarjuna Paper Mills Limited versus SDM and RD officers. The case is of 1987 Criminal Law Journal 2071, Andhra Pradesh. The question was whether the STM has the power under this section to order a factory to be closed on the grounds of causing pollution. It was held that Water Act 1979 was not taken away by the power of SDM under section 133, and he can pass orders under section 136 to close a factory causing pollution when appreciation certificate is not produced. Now we come to the fourth point of public nuisances, consequences of his failing to do so as per the provision of section 136. Section 136 says, if such person does not perform such act or appears and show cause, he shall be liable to the penalty prescribed in that behalf in section 188 of the Indian Penal Code, and the order shall be made absolute. In simple words, in section 135, the person was asked either to obey the orders, stop such nuisances, or show cause notice why action should not be taken against him. And if he does not appear, this is what section 136 says, if he does not appear, the penalty can be imposed upon him under section 188 of Indian Penal Code. Section 188 of IPC, it says it is punishable with simple imprisonment, which may extend to 1 month, or fine up to rupees 200, or both. Fifth point is section 137, procedure where existence of public right is denied. Subsection 1 of section 137 says, where an order is made under section 133 for the purpose of preventing obstruction, nuisance, or danger to the public in the use of any way, river, channel, or place, the magistrate shall, on appearance before him of the person against whom the order was made, question him as to whether he denies the existence of any public right in respect of the way, river, channel, or place, and if he does so, The magistrate shall, before proceeding under section 138, inquire into the matter. So basically, section 137 subsection 1 says magistrate inquiry will be done when the person denies any such nuisance, obstruction or danger to the public in the use of four things that the section is talking about. The fourth thing is way, river, channel or place. Next, subsection 2 of section 137 says, if in such inquiry the magistrate finds that there is any reliable evidence in support of such denial, he shall stay the proceedings until the matter of the existence of such right has been decided by a competent court. And if he finds that there is no such evidence, he shall proceed as laid down in section 138. So, subsection 2 of section 137 speaks about two things. One, if the evidence shows that there is no such nuisance, then definitely he will stay the proceedings. But if he thinks there is some kind of nuisance created by that person, then he will proceed as per the procedure laid down in section 138, which we are going to cover next. In subsection 3 of section 137, it is said that a person who has, on being questioned by the magistrate under subsection 1, failed to deny the existence of a public right of the nature therein referred to, or who, having made such denial, has failed to adduce reliable evidence in support thereof, shall not in the subsequent proceedings be permitted to make any such denial. It simply means a person who has failed to deny the existence of any such public right, he will not be allowed to deny at later stage that there is no public right to the four things which we have discussed: way, river, channel and place. Sixth point, procedure where he appears to show cause as per the provision of section 138. Subsection 1 of section 138 says, if the person against whom an order under section 133 is made appears and show cause against the order, the magistrate shall take evidence in the matter as in a summon case. So a person has been summoned and he appears. That case will be taken up as a summon case. This is what subsection 1 of section 138 says about. Subsection 2 of section 138 says, if the magistrate is satisfied that the order, either as originally made or subject to such modification as he considers necessary, is reasonable and proper, the order shall be made absolute without modification, or as the case may be, with such modifications. So subsection 2 gives option to the magistrate that he may either make some modification in his order or continue with the order that he had made. Subsection 3 of section 138 says, if the magistrate is not so satisfied, no further proceedings shall be taken in the case. So subsection 3 of section 138 basically is the conclusion of the magistrate, which says that if the magistrate is not satisfied, no further proceeding will be taken place. He will just close the case. Seventh point of public nuisances: power of magistrate to direct local investigation and examination of an expert as per the provision of section 139. Section 139 says, the magistrate may, for the purposes of an inquiry under section 137 or section 138, direct a local investigation to be made by such person as he think fits as per clause A, or summon and examine an expert as per clause B. Nothing to explain, it is self-explanatory that magistrate, for local investigation, he has two options: either direct a local investigation from any person whom he thinks fit for such investigation, or he may ask an expert to come to the court by sending summons to him to appear before the court. Eighth point of public nuisances: power of magistrate to furnish written instructions and examination of an expert. Subsection 1 of Section 140 says where the magistrate directs a local investigation by any person under Section 139, the magistrate may do the following. Clause A of Subsection 1 of Section 140 says furnish such person with such written instruction as may seem necessary for his guidance. Clause B of subsection 1 of section 140 says, declare by whom the whole or any part of the necessary expenses of the local investigation shall be paid. So, subsection 1 of section 140 explains us that investigation has been ordered by the magistrate under section 139. Now, there are two things. One, for such investigations, the magistrate can give some written instruction for his guidance. Number two, the magistrate can make a declaration that who is going to pay for the expenses of local investigation. Also, whether the payment has to be paid in whole or in part. In part means it can be a portion of payment, half, one third, etc. Now we come to subsection 2 of section 140. It says the report of such person may be read as evidence in the case. Okay, so whatever the report is going to be furnished in such investigation, it will be considered as evidence. Subsection 3 of section 140 says where the magistrate summons and examines an expert under section 139, the magistrate may direct by whom the cost of such summoning and examination shall be paid. So this is on the discretion of the magistrate that the expenses of the expert shall be paid by which person. Ninth point of public nuisances. Procedure on order being made absolute and consequences of disobedience as per the provision of section 141. Subsection 1 of section 141 says where an order has been made absolute under section 136 or 138 as the case may be, the magistrate shall give notice of the same to the person against whom the order was made and shall further require him to perform the act directed by the order within a time to be fixed in the notice, and inform him that in case of disobedience, he will be liable to the penalty provided by section 188 of Indian Penal Code. It simply means that when a person is ordered under 136 or 138 that he is creating public nuisance, he has to take some action, and that time will be given in the notice. And also mentioning in the notice that if you don't obey these orders within the stipulated time, he will be liable for penalty, which is given under section 188 of Indian Penal Code. Now let's revise what section 188 of Indian Penal Code says. It says if you disobey the orders of a public servant, which is the magistrate in this case, you will be punished for simple imprisonment for 1 month or fine of rupees 200 or both. Now let's check subsection 2 of section 141 says if such act is not performed within the time fixed, the magistrate may cause it to be performed and may recover the cost of performing it either by the sale of any building, goods or other property removed by his order or by distress and sale of any other movable property of such person within or without such magistrate's local jurisdiction. And if such other property is without such jurisdiction, the order shall authorize its attachment and sale when endorsed by the magistrate within whose local jurisdiction the property to be attached is found. So subsection 2 actually gives power to the magistrate that if such person is not removing the nuisance, like keeping or selling things on the payment, this is what we commonly see, then they will cause it to be removed by the municipal corporation, which we again see that the people of municipal corporation are taking away the articles being sold on the payment on the footpath, and any such expenses which is occurred by the municipal corporation will be recovered by selling those articles even if it is outside the jurisdiction of the court. Now let's check what subsection 3 of 141 says. It says no suit shall lie in respect of anything done in good faith under this section, Well, any action taken by the magistrate will not be liable in the court of law because it has been done in good faith. This is actually a condition. It should have been done in good faith. 10th point of public nuisances is injunction pending inquiry as per the provision of section 142. Subsection 1 of section 142 says if a magistrate making an inquiry under section 133 considers that immediate measure should be taken to prevent imminent danger or injury of a serious kind to the public, he may issue such an injunction to the person against whom the order was made as is required to obviate or prevent such danger or injury pending the determination of the matter. Now, what do we understand by this? First, we should remember that section 142 is controlled by section 133. Measures to prevent imminent danger or injury of a serious kind to the public may be taken under this section only in case of matters dealt in section 133 and not otherwise. Subsection 2 of section 142 says, in default of such person forthwith obeying such injunction, the magistrate may himself use or cause to be used such means as he thinks fit to obviate such danger or to prevent such injury. Again, subsection 2 is saying that if the person is not obeying the orders of the magistrate, which is done under section 133, then he may take any urgent action as he thinks fit. Subsection 3 of section 142 says, no suit shall lie in respect of anything done in good faith by the magistrate under this section. As usual, no action will be taken against the magistrate if he has taken any action in good faith. Now we come to the last point of public nuisances. 11th point, magistrate may prohibit repetition or continuance of public nuisances as per the provision of section 143. Section 143 says a district magistrate or subdivisional magistrate or any other executive magistrate empowered by the state government or the district magistrate in this behalf may order any person not to repeat or continue a public nuisance as defined in the Indian Penal Code or any special or local law. In simple words, under section 143, a magistrate, a subdivisional magistrate or executive magistrate, as the case may be, empowered by the state government, a magistrate can say to the offender, don't do it again. Now we come to the third part of chapter, Maintenance of Public Order and Tranquility, Part C, Urgent Cases of Nuisances or Apprehended Danger. As per the provision of section 144, only one section is given in this part. Part C, Urgent Cases of Nuisances or Apprehended Danger. As per the provision of section 144, it says power to issue order in urgent cases of nuisances or apprehended danger. Subsection 1 of section 144 says in cases where, in the opinion of district magistrate, a subdivisional magistrate, or any executive magistrate, specially empowered by the state government in this behalf, there is sufficient ground for proceeding under this section and immediate prevention or speedy remedy is desirable, such magistrate may, by a written order stating the material facts of the case and served in the manner provided by section 134, direct any person to abstain from a certain act or to take certain order with respect to certain property in his possession or under his management if such magistrate considers that such direction is likely to prevent or tend to prevent obstruction, annoyance, or injury to any person lawfully employed, or danger to human life, health, or safety, or a disturbance of the public tranquility, or a riot, or an affair. Subsection 1 of Section 144 says the district magistrate, subdivisional magistrate, or the executive magistrate may proceed under this section only when immediate prevention or a speedy remedy is desirable, and he must be satisfied to certain things. Number one, there is a danger to human life, there is disturbance of public tranquility, or a riot or an affair. This is going to be a question in judicial examination. What are the dangers? It may be to human life, disturbance of public tranquility, riot, or an affair. Let's take up an interesting case. Ram Manohar versus Sundaram, AIR 1955, Manipur 41. In this case, it was held where there is no apprehension of a breach of peace. A magistrate should not restrain the liberty of private individual by means of an order under this section. So, we should not forget that the orders under this section can be made only when there is apprehension to the four things: danger to human life, public tranquility, riot, or an affair. Now let's check what subsection 2 of section 144 says. It says an order under this section may, in cases of emergency or in cases where the circumstances do not admit of the serving in due time of the notice upon the person against whom the order is directed, be passed ex parte. The bare language is very simple over here. It simply says it is an emergency. We cannot reach the person and ex parte decision will be taken. Subsection 3 of section 144 says an order under this section may be directed to a particular individual or a person residing in a particular place or area, or to the public generally when frequenting or visiting a particular place or area. Now this is very interesting. An ex parte decision has been taken in emergency as we read in subsection 2. Now subsection 3 says that such decision, such order, which is either to be directed to a particular person or public at large at a particular place. So how are we going to serve it? Well, we can give it to a person residing in that place and paste it in a conspicuous place. Obviously, it's an emergency. Next, subsection 4 of section 144 says no order under this section shall remain in force for more than 2 months from the making thereof. So, subsection 4 of section 144 says such order has an expiry date. It expires within 2 months from the order it has been made. Provided that, now we have a condition for it. If the state government considers it necessary to do for preventing danger to human life, health, or safety, or preventing a riot or an affair, it may by notification direct that an order made by a magistrate under this section shall remain in force for such further period not exceeding 6 months from the date on which the order made by the magistrate would have, but for such order expired as it may specify in the said notification. Now let's not be confused with it. Subsection 4 of section 144 says any such order shall remain in force only for 2 months from the date when it was issued. But the state government may, if it considers necessary, by notification direct that an order made by the magistrate, which is to be enforced for 2 months, will continue for a period not exceeding 6 months. So, the order of the magistrate, which remains in force for 2 months, can be extended up to 6 months by the order of the state government. Now let's check subsection 5 of section 144. It says any magistrate may, either on his own motion or on the application of any person aggrieved, rescind or alter any order made under this section by himself or any magistrate subordinate to him or by his predecessor in office. So subsection 5 says any alteration to be made in the order. That can be done either on application by the aggrieved person or even the magistrate himself can do so. Next is subsection 6 of section 144. It says the state government may either on its own motion or on the application of any person aggrieved rescind or alter any order made by it under the proviso to subsection 4. Now, when we have given the power to the state government that they can extend the notification, they have the power to alter it as well. So, state government can do so. Now we come to the last subsection of section 144. It is subsection 7 of section 144, where an application under subsection 5 or subsection 6 is received, the magistrate or the state government, as the case may be, shall afford to the applicant an early opportunity of hearing before him or it, either in person or by pleader, and showing cause against the order. And if the magistrate or the state government, as the case may be, rejects the application wholly or in part, he or it shall record in writing the reason for doing so. Subsection simply says the agreed person against whom the order has been made, if he approaches the court under subsection 5 or under subsection 6, he will be given the earliest opportunity of hearing. On other hand, if his application is rejected wholly or in part, either by the state government or the magistrate, they will give it in writing the reasons for rejecting his application. With this, we come to the end of the topic urgent cases of nuisances or apprehended danger as per the provision of section 144 of Criminal Procedure Code. Now we come to the fourth and the last part of the chapter 10, Maintenance of Public Order and Tranquility. Part D, Disputes as to Immovable Property. It is given as per the provision of section 145 to 148. Only 4 sections are there in this part. First point of the topic disputes as to immovable property is procedure where dispute concerning land or water is likely to cause breach of peace as per the provision of section 145. Before I start this section 145, let me tell you it has 10 subsections. So I will try that you don't get bored while covering all the 10 subsections. Subsection 1 of section 145 says, whenever an executive magistrate is satisfied from a report of a police officer or upon other information that a dispute likely to cause a breach of the peace exists concerning any land or water or the boundaries thereof within his local jurisdiction, he shall make an order in writing stating the grounds of his being so satisfied and requiring the parties concerned in such dispute to attend his court in person or by pleader on a specified date and time, and to put in written statements of their respective claims as respect the fact of actual possession of the subject of dispute. Looks difficult, right? But it has nothing in it. Subsection 1 of section 145 says the executive magistrate, on the report of a police officer or other information, will make an order to the parties to the dispute to come to the court and bring the facts in front of the court regarding the dispute of a land or a water. That's it. Simple. Next is subsection 2 of section 145. It says, for the purposes of this section, the expression land or water includes building, markets, fisheries, crops, or other produce of land, and the rents or profits of any such property. So subsection 2 of 145 is indirectly explaining us the term land and water. And in judicial examination, it might ask, what does the expression land and water includes? Then you have to see whether the options are buildings, markets, fisheries, crops, or other produce of land. It also includes the rents or profits of any such property, which we think is not going to be the expression of land or water, but subsection 2 is explaining us. So do remember it. Next, subsection 3 of section 145. A copy of the order shall be served in the manner provided by this code for the service of a summons upon such person or persons as the magistrate may direct, and at least one copy shall be published by being affixed to some conspicuous place at or near the subject of dispute. So, subsection 3 of section 145 says the copy of the order will be served to the person as summon is served, and one such copy will be affixed, pasted at a place of dispute. Simple. Subsection 4 of section 145 says the magistrate shall then, without reference to the merits or the claim of any of the parties to a right to possess the subject of dispute, pursue the statements so put in. Hear the parties, receive all such evidence as may be produced by them, take such further evidence, if any, as he thinks necessary, and, if possible, decide whether any and which of the parties was, at the date of the order made by him under subsection 1, in possession of subject of dispute. Subsection 4 says, in subsection 1, we had called in for written statement from the parties to the dispute. Now, these parties are going to represent their case. They will bring forward whatever evidence they have. So, the magistrate will look into the merits of the claim of the parties as to who has the right to take evidence and even seek further evidence. Now, let's check what is the condition to subsection 4 of section 145. Provided that if it appears to the magistrate that any party has been forcibly or wrongfully dispossessed within 2 months next before the date on which the report of the police officer or other information was received by the magistrate, or after that date and before the date of his order under subsection 1, he may treat the party so dispossessed as if that party had been in possession on the date of his order under subsection 1. So the condition is explaining us two things. If the party has been forcibly or wrongfully dispossessed, means he is not in possession of the property anymore within 2 months from the date of the report of the police, or before or after the orders of the magistrate, he will be considered to be in possession of the property, so that he can be fixed for his wrong. Subsection 5 of section 145. Nothing in this section shall preclude any party so required to attend, or any other person interested, from showing that no such dispute as aforesaid exists or has existed, and in such case the magistrate shall cancel his said order, and all further proceedings thereon shall be stayed, but subject to such cancellation the order of the magistrate under subsection 1 shall be final. So in subsection 5 of section 145, it is informing us that nothing in this section is preventing any party, any person to approach the court, that there is no dispute at all. In such case, the magistrate obviously will cancel his order which he made under subsection 1 of section 145. But if there is nothing like this, then the orders of the magistrate under subsection 1 shall be considered as final. Next is subsection 6 of section 145. Clause A of subsection 6 says, if the magistrate decides that one of the parties was or should be under the proviso to subsection 4 be treated as being in such possession of the said subject, he shall issue an order declaring such party to be entitled to possession thereof until evicted therefrom in due course of law, and forbidding all disturbances of such possession until such eviction, and when he proceeds under the proviso to subsection 4 may restore to possession the party forcibly and wrongfully dispossessed. Subsection 6, Clause A of Section 145. It is informing us where a person is in possession of a disputed property. The magistrate may, for the time being, can order that he can look after the property until and unless he is evicted from that property as per the procedure of law. The property may also be restored to the person who was wrongfully or forcibly thrown out of the possession. Means he was dispossessed. So the possession will be given back to that person who is the real owner. Further, Clause B of subsection 4 of section 145 says, the order made under this subsection shall be served and published in the manner laid down in subsection 3. So whatever the order is going to be made, it will be published as it already given under subsection 3. Next, subsection 7 of section 145. When any party to any such proceedings dies, the magistrate may cause the legal representative of the deceased party to be made a party to the proceedings and shall thereupon continue the inquiry. And if any question arises as to who the legal representative of the deceased party for the purposes of such proceeding is, all persons claiming to be representatives of the deceased party shall be made parties thereto. Well, nothing much to explain in this. If a party to any such proceeding dies, the legal representative takes over. If there is a dispute to who is the legal representative, all who are claiming will be made legal representative. Anyway, we can say this is given under subsection 7 of section 145 of Criminal Procedure Code 1973. Next, subsection 8 of section 145. It says if the magistrate is of opinion that any crop or other produce of the property, the subject of dispute in a proceeding under this section pending before him, is subject to speedy and natural decay, he may make an order for the proper custody or sale of such property, and upon the completion of the inquiry shall make such order for the disposal of such property or the sale proceeds thereof as he thinks fit. I hope everybody understood it. The inquiry takes time. During that time, if there is a crop or some property which is of perishable nature, which is subject to speedy decay, well, then magistrate may either order for a proper custody of it or may even sell that property. Don't worry, the sale proceed will be given to the owner. Okay, now we come to the ninth point, subsection 9 of section 145. The magistrate may, if he thinks fit, at any stage of the proceedings under this section, on the application of either party, issue a summons to any witness directing him to attend or to produce any document or thing. Nothing to explain much in it. The magistrate may at any stage, either on the application of the party or on its own, summon any witness. And he may ask him to even produce a thing or a document. Anyway, last point, subsection 10 of section 145. It says nothing in this section shall be deemed to be in derogation of power of the magistrate to proceed under section 107. Now it says that this section 145 will not limit the power of a magistrate which is given under section 107. Now section 107 is a power of an executive magistrate to seek a bond for keeping peace. Second point of the topic is power to attach subject of dispute and to appoint receiver. So there are two things: to attach subject of dispute and to appoint receiver. Subsection 1 of section 146 says, if the magistrate at any time after making the order under subsection 1 of section 145 considers the case to be one of emergency, or if he decides that none of the parties was then in such possession as is referred to in section 145, or if he is unable to satisfy himself as to which of them was then in such possession of the subject of dispute, he may attach the subject of the dispute until a competent court has determined the rights of the parties thereto with regard to the person entitled to the possession thereof. Now, there is a condition to it as well, provided that such a magistrate may withdraw the attachment at any time if he is satisfied that there is no longer any likelihood of breach of the peace with regard to the subject of dispute. Now, this is a condition when on inquiry the magistrate is unable to determine as to which of the parties was in possession. He may attach the property. He may do so after proper inquiry, hearing of the parties, and express finding to that effect. When the civil court has determined possession, it would not be proper to attach on the ground of inability to determine it. If the magistrate is not able to decide as to the possession of a part of the property, he will proceed under section 146 in respect of that part only and declare possession of the remainder. This was also held in a case Sadr Ali versus Abdul Karim 5 CWN 710. The proviso to subsection 1 enables a magistrate to withdraw the attachment whenever he is satisfied that there is no longer any apprehension of breach of the peace. Next, subsection 2 of section 146. When the magistrate attach the subject of dispute, he may, if no receiver in relation to such subject of dispute has been appointed by any civil court, make such arrangements as he considers proper for looking after the property, or if he thinks fit, appoint a receiver thereof, who shall have, subject to the control of the magistrate, all the powers of a receiver appointed under the Code of Civil Procedure 1908, provided that in the event of a receiver being subsequently appointed in relation to the subject of dispute by any civil court, the magistrate, clause A, shall order the receiver appointed by him to hand over the possession of the subject of dispute to the receiver appointed by the civil court, and shall thereafter discharge the receiver appointed by him. Clause B says, may make such order incidental or consequential orders as may be just. Subsection 2 is explaining us that the magistrate can make arrangements as he considers proper for looking after the property. He may even appoint a receiver if no receiver has already been appointed by civil courts. Third point of the topic, dispute as to immovable property, is dispute concerning right of use of land or water as per the provision of section 147. Subsection 1 of section 147 says, whenever an executive magistrate is satisfied from the report of a police officer or upon other information that a dispute likely to cause a breach of peace exists regarding any alleged right of user of any land or water within his local jurisdiction, whether such right be claimed as an easement or otherwise, he shall make an order in writing stating the grounds of his being so satisfied and requiring the parties concerned in such dispute to attend his court in person or by pleader on a specified date and time, and put in written statement of their respective claims. The explanation says The expression land or water has the meaning given to it in subsection 2 of section 145. Now this is a bit complicated situation for the magistrate. He has not only to see whether the right of use which has been claimed in the property exists, and he has to even find whether such right existed 3 months before institution of the inquiry or during the last season or occasion before the institution of the inquiry. One more important fact, where the rights of the parties has already been determined by a court of law, the magistrate cannot take proceedings under this section. It was held in Niranjan Behra, Behara versus Lakshmidhar Rana, Laxmidhar Rana, Rana. 1991 Criminal Law Journal, 1599, Odisha. In this case, it was held that in absence of express powers under section 147 to pass interim or interlocutory orders, the magistrate must be deemed to have implied powers to pass an interim order in order to prevent hardship to any party. This is a good example to explain section 147. Now let's take subsection 2 of section 147. It says the magistrate shall then pursue the statement so put in. Here the parties receive all such evidences as may be produced by them respectively, consider the effect of such evidence, take such further evidence, if any, as he thinks necessary, and, if possible, decide whether such rights exist, and the provision of section 145 shall, so far as may be, apply in the case of such inquiry. So subsection 2 is basically explaining the court procedure that the magistrate will pursue the statements. Here the parties receive evidence, and if required, magistrate may take further evidence and finally decide whether such right exists or not. Subsection 3, it says that if it appears to such magistrate that such right exists, he may make an order prohibiting any inferences with the exercise of such right, including in a proper case an order for the removal of any obstruction in the exercise of any such right. So subsection 3 is explaining us that the magistrate is to satisfy himself that the right of user claimed appears to exist. Now point to note over here is that it appears to exist, not that is to be strictly proved. And on other hand, the right of easement is not required to be proved. The fact of the user is sufficient. With the explanation I have already covered provided that thing. Now let's come to the subsection 4 of section 147. It says when in any proceedings commenced under subsection 1 of the section 145, the magistrate finds that the dispute is as regards an alleged right of user of land or water, he may, after recording his reasons, continue with the proceedings as if they had been commenced under subsection 1. And when in any proceedings commenced under subsection 1, the magistrate finds that the dispute should be dealt with under subsection 145, he may, after recording his reasons, continue the proceedings as if they had been commenced under subsection 1 of section 145. So subsection 4 basically informs us that when any proceeding has already been started under subsection 1 of section 145 and magistrate finds that there is dispute regarding the alleged use of either the land or the water, he may continue the proceedings which has been started under subsection 1 of section 145. That's it. Now we come to the fourth and the last point of the topic, disputes as to immovable property. Local inquiry as per the provision of section 148. Subsection 1 of section 148 says Whenever a local inquiry is necessary for the purposes of Section 145, Section 146, or Section 147, a district magistrate or subdivisional magistrate may depute any magistrate subordinate to him to make the inquiry and may furnish him with such written instructions as may seem necessary for his guidance, and may declare by whom the whole or any part of the necessary expenses of the inquiry shall be paid. So, for local inquiry, divisional magistrate or subdivisional magistrate may depute a magistrate subordinate to them. So, the junior most magistrate will be given the work of inquiry, and some instruction will be given that how it is to be done for his guidance, and the expenses may also be decided that who is going to pay for such expenses. Subsection 2 of Section 148 says the report of the person so deputed may be read as evidence in the case. Now, the report which is going to be prepared can be used as an evidence in this case. Subsection 3 of Section 148 says when any cost has been incurred by any party to a proceedings under Section 145, Section 146, or Section 147, the magistrate passing a decision may direct by whom such cost shall be paid, whether by such party or by any other party to the proceedings, and whether in whole or in part, or proportion, and such cost may include any expenses incurred in respect of witnesses and of pleaders' fees which the court may consider reasonable. So the subsection 3 is actually explaining us regarding the cost when the decision is to be taken by the magistrate. It should ordinarily be passed simultaneously with the final order on merits. It is only the magistrate who can decide by whom costs are to be paid. Cost awarded under this section must be reasonable. Okay, finally we come to the end of this chapter 10. Before we start another one, don't forget to respect your parents.